How many holders support Ripple? When will the SEC listen to reason? Will XRP cost $2? We will answer all these questions in today's video. Wally thinks Ripple's case against the Securities and Exchange Commission will be resolved in favor of the XRP progenitor. Prominent crypto supporter John E. Deaton has hinted at what may happen if the securities watchdog wins. Is Ripple capable of defeating the SEC? Ripple has won multiple procedural wins, leading XRP supporters to anticipate that Ripple will win the 2-year court fight. Nevertheless, if things don't go as planned and presiding Judge Analisa Torres believes the SEC's claim that all XRP transactions, including those done on secondary markets, are securities, the Commission's triumph may mean difficulties for many other crypto-focused businesses. According to John Deaton, this is the case. Deaton stated that a favorable verdict for the SEC would provide its chair, Gary Gensler, the necessary cover as well as the impetus to file similar claims against corporations operating in the digital asset market. The XRP lawyer's remarks were in reaction to a tweet from Fox Business writer Eleanor Terrett, who revealed some details concerning the recent closure of Signature Bank. Significantly, no reason was provided when the New York Department of Financial Services announced the closure of Signature on Sunday. Terrett referenced former Congressman Barney Frank, who pointed out that sending an anti-crypto message was a planned act. Ripple is a cryptocurrency industry behemoth in the United States, developing real-world goods based on breakthrough technology. In December 2020, the SEC threw a bombshell on the burgeoning industry by suing the business and 2 of its senior executives for illegally generating over $1.03 billion via the sale and distribution of the XRP cryptocurrency. The primary issue in the case is whether XRP is a security, and the outcome of the court hearing will decide the token's destiny. Most crypto commentators feel that Ripple has the upper hand in the long-running legal dispute. Nonetheless, the SEC suffered a defeat last month when the court declined to dismiss Ripple's essential fair notice argument. The judge's verdict, which is anticipated in June, will almost certainly be a watershed moment for XRP and the larger crypto market. Yet, if Ripple wins, XRP might make a run towards $1. According to attorney John E. Deaton, the emails and papers relating to writing Bill Hyman's contentious 2018 address at the Yahoo Finance All Markets Summit, known as the Hyman Materials, will ultimately become public. If Judge Analisa Torres cites the documents in her summary judgment decision in the United States Securities and Exchange Commission (SEC) case against Ripple, she is likely to declare them judicial documents, making them publicly accessible with some redactions, as explained by the CryptoLaw founder in a Twitter thread yesterday. Furthermore, he points out that the Hyman records are also important in current litigation, noting the action against Dragon Chain over Dargon, an Ethereum blockchain token that the SEC also claims is an unregistered security. The lawyer emphasizes that access to the Hyman papers is more crucial to the defense in this case than Ripple's fair notice argument, and he also reminds community members that courts have already granted SEC attorney client privilege arguments. Hyman, the then director of the SEC's Division of Corporate Finance, said in the contentious speech that ETH is not a security since the blockchain is sufficiently decentralized. This is the same blockchain that Dargon is built on, as mentioned above. Deaton also said that Dr. Rosalind Layton, a policy scholar, had filed a petition in the Ripple case contesting the SEC's attempt to seal the records. Deaton also claims to have submitted a similar request under the Freedom of Information Act, which he plans to pursue. As a result, the SEC's enforcement action against Ripple over XRP 2 years later astonished many in the crypto world, prompting the Ripple defense to seek documents connected to the speech draft. Importantly, it begs the issue of why the government opted to target Ripple rather than Ethereum. Remember that the SEC first denied Ripple's request, claiming that the speech reflected Hyman's personal ideas and was therefore irrelevant to the case. When forced by the court to produce the materials, the agency changed its story, stating that Hyman wrote the speech with the assistance of the agency's attorneys, citing attorney client privilege. Nevertheless, the SEC ultimately gave up the records to Ripple in October. After 18 months and 6 court orders from 2 courts, Dr. Layton noted after submitting her application for access to the records that they would reveal whether there were any malicious reasons for the Ethereum free pass or if there is uncertainty among regulators, which would excuse perplexity among industry players. The SEC wants you to believe that it is concerned with disclosure, openness, and clarity. They are not to be believed. The shamefulness of their actions here will shock you when the truth comes out. Ripple Chief Executive Officer Brad Garlinghouse tweeted after the blockchain payment startup acknowledged receipt of the disputed papers. If Ripple prevails in its legal fight with the U.S. Securities and Exchange Commission, SEC, the relisting of the XRP token on the main U.S. crypto exchange Coinbase will be one of the greatest headlines in the XRP ecosystem. In a recent interview, Coinbase's chief legal officer, CLO, Paul Grewal, has talked in depth about the matter and outlined how the XRP relisting process would work. Coinbase banned XRP trading in January 2021, soon after the SEC filed its complaint, and has since kept the coin suspended despite vociferous XRP community requests. Grewal stated his hope for a Ripple triumph in yesterday's discussion with Thinking Crypto presenter Tony Edward, but also highlighted that a relisting does not rely entirely on a trial court success. Grewal said that the U.S. crypto exchange assesses assets on a regular basis for listing, delisting, or halting. He also understands the XRP community's angst. I realize it has been irritating for many XRP holders that they have not been able to trade their assets on Coinbase while this SEC action has been ongoing, Grewal said, adding that the SEC has not prevented Coinbase from closely monitoring the state of the dispute. Grewal, like everyone else, is looking forward to the judgment and lauding Ripple's attorney's efforts. I definitely paid attention to the fact that the defendants in this case have done a fantastic job of pushing the SEC and raising fundamental concerns about the SEC's overall argument. Coinbase has filed an amicus brief in favor of some of Ripple's arguments. According to Grewal, Ripple's CEO Stuart Alderety and the rest of the fintech business have done an amazing job, which is why he believes the court will rule in Ripple's favor. We'll show that the SEC ideas are flawed. I believe the briefing in this case has been outstanding, and we will all soon see what the trial judges think of the arguments. Nonetheless, the Coinbase CLO emphasized that, in his judgment, the Southern District Court of New York's ruling is merely the first stage in a prolonged process. Grewal feels that regardless matter who wins in court, both parties in the case will appeal. Grewal added that the timing for relisting following the trial court judgment relies on the reasons of the judgment, the judge's legal rationale, and Coinbase's opinion of whether or not the decision would be upheld by the appeals court. Therefore, a lot is going to rely on the particulars of that court rulings. I realize it won't be very pleasing for some, but as a publicly traded firm, we have a duty to tread cautiously in this area, and with regard to any token that's the subject of federal court action, Grewal said. Finally, the Coinbase CLO said that the exchange would begin the review process as soon as the judgment is published. So, like everyone else, I am curious to see how the court decides, and all I can say is that as soon as we obtain the verdict, we will begin our process to see if we need to reconsider our listing decision.